What's up, everybody? We are catching up on the Scot Peterson trial as the state has rested their case. And the defense will start, or depending on when you hear this or watch this, has started to call their witnesses and present their evidence, which we are told by defense attorney for Scot Peterson will be a mountain of evidence that he can back up. We've already seen some of it come in and cross, so I have no doubts that we are going to see that. But I did want to talk about a couple other witnesses that were called over the last few days. So we're going to get into that today and get into the state actually resting their case and what that means and the arguments that the defense makes for, a JOA, a judgment of acquittal that always loses. But first, hit that like button if you are still interested in the Scot Peterson content, because this trial is going on at the same time as Melly and Koberger's happening and all this stuff is happening. So if you guys aren't interested in this trial anymore, let me know. But if you are, you can let me know by hitting that like button and subscribing to our page. The first witness I'm going to talk about is the medical examiner who testified in excruciating detail that none of us really want to hear. And we've talked about how they do have to prove damages, but it is not, the damages are not even, being argued in this case as far as if Scot Peterson caused the damages or had a duty that he breached. That's the big argument here, not the fact that these children were damaged. And that is why you can always see a good indication of that when the defense has no cross-examination for a state witness, which is exactly what happened there. But then we got one of the witnesses I do want to focus on in today's video, which was a security monitor who was there responding kind of same time and hearing some similar things to Scot Peterson. I think he was a good witness, former military, but not trained police officer. But we got to hear from him what he saw, what he thought, what he did. And he talked about how he heard gunshots. Peterson had the firearm in his hand. Peterson was doing certain things, but that he had a blank expression on his face and looked like he didn't know what was going on. He didn't really recall the fire alarm, which I thought was weird since everybody has seemed to recall that. But I do want to talk about what he did, because I saw a lot of people saying, this is what you have to do. This is what you have to do. You have to do something. And even if it goes against your training or what the policy is, you still have to do something, which is basically what this guy said. So we're going to hop into his testimony here, listen to some of what he had to say. Here we go.
What was your responsibility during the code red trial?
Well, took code red, should have completely locked down. I should have went and took cover, locked myself into a security place. But I just took it upon myself, I guess, to go where the problem was located, where the problem was reported.
So he was told, and what he's supposed to do, standard operating procedure, is hide, lock himself down, basically. But he took it upon himself to go towards where he thought the problem was, because it was reported to be at a certain location.
It was reported 1200, so I went, and once I heard the gunshots, technically I should have went and locked myself down.
But what did you do instead?
Make sure those kids were safe.
What did you do instead? Make sure those kids were safe. And I think that's what a lot of us wanted to hear, and what we were hoping everybody did in that situation. And now we're on trial here, listening to it to see if a certain person, Scot Peterson, did not do that. That's the big question here.
During the code red, based upon the training in January as well as other trainings being a security specialist, do you know what Mr. Peterson's job was during the code red?
Deputy Peterson? No, I'm not sure.
Weird smile to me. It's not like a disappointed, sad smile. It's almost like a funny smile. I don't really know what to read into it, but that's why video is kind of makes this more interesting. But I don't know. It was kind of a weird smile when he got this question.
Now, after putting the children back into different classrooms, where did you go to next?
I went to the camera room.
Where's the camera room located?
Camera room is in building 1.
Going back to States 1. Building 1?
Yes.
Who did you go with?
Mr. Morford, assistant principal.
when you went to the camp, or is the
All right. So that was the part I wanted to hear there. And then I want to jump up to what he actually saw because he was there. So what did he actually see Peterson doing? Because this is what's most important to me, right? Other people that are going to come in and Monday morning quarterback it and say, I would have done this, I would have done that. And he didn't, and therefore he's wrong, right? That's different than people that were actually there, seeing it, living it, acting it out with him, which this guy was. So let's hear what he has to say.
how long were you with Mr. Peterson in that general area that we just saw?
2 minutes?
Did you say
Over 2 minutes?
over 2 minutes? During that point in time, did Mr. Peterson leave the spot with his name?
No, sir.
Over that point in time, did you see Mr. Peterson do anything besides operate the radios?
No, sir.
So yeah, I just wanted to listen to it again because he basically said, did you see Mr. Peterson do this? Did you see Mr. Peterson do that? And the answer was no. So basically he's saying while he was there, Peterson didn't do anything. Okay. But on cross, he confirmed Mr. Peterson's not a coward. He had positive things to say about Scot Peterson. Sometimes you miss things over the school radio. That's not unusual. And he confirmed that Peterson's radio always messed up. Always messed up. He also said he was not a lazy cop and he was trying to do stuff. Then he brought up again another thing that was very frustrating for the people that were actually there. Did Medina know things that he did not tell Peterson and this security specialist or monitor?
Nothing to you guys while you're in the golf cart.
No.
And I see you making a face. Why tell jurors why that frustrates you?
Well, because it could have taken a lot of guesswork out, pretty much what was going on, because he knew exactly what was going on.
Gosh, the sound is so horrible. So what he was saying is Medina should have told them that he saw what he saw at the 1200 building, but he didn't. He didn't tell Peterson and he didn't tell this witness.
Tell the jurors what you mean by that. Medina knew what was going on. He didn't tell you that.
Correct. Well, he saw the kid walk into the 1200 building. He knew exactly how many people had walked into the building. And he knew that that particular person walked in carrying a rifle bag.
So he saw a suspicious person, the shooter, walk into the 1200 building. He saw him carry a rifle bag and he did not tell anybody. And that guy is not on trial, right? He knew all this information. They could have known exactly where it was. We could have erased all of this. If he would have just told Scot Peterson and this witness, maybe they would have been able to have done more. But this is so revealing because this seems like the big problem here. They did not get the information, and that's what the defense has kind of been pushing this whole trial.
How does that make you feel?
When I did, 17 people I killed.
You believe that part of Medina's job as a monitor is to convey that important information to both you and Deputy Peterson, correct?
Correct.
So he believes that Medina, as a security monitor, his job was to relay that information to Deputy Peterson and this witness. And he didn't do it. So again, these are all breaks along the chain where at the end of the chain, Peterson's like, what am I supposed to do? I didn't have this information. If I had it, then I didn't go towards the 1200 building. Fine. Then you got me. But I didn't have this information. It wasn't coming over the radio. My radio was messed up. Coral Springs wasn't sharing information with us. This guy didn't have the information either.
You lost sleep over it, haven't you?
Objection, Your Honor.
He said you lost sleep over it. Objection.
Yeah, that's the thing. Okay, sir, ask your next question. You do see my client on his police radio all the way to the 1200 building, correct?
Yes, sir.
And you remember him listening intently, correct?
Yes, sir.
Trying to gather real-time intelligence, correct?
Yes, sir.
And so it's exact opposite, right? On direct, they were talking about all the stuff he didn't do. Now on cross, they're talking about all the stuff Peterson did do.
So when you arrive at the 1200 building, both you and Deputy Peterson get off of the golf cart, correct?
Yes, sir.
I'd like to go through the video and have you take us through that. Peterson leaving that building, correct?
Let's go. Let's have the one stop.
2/22/14 we're seeing, right?
Yes, sir.
And so that's, who's that in the hall with you and Deputy Peterson?
Yes, sir.
No, stop, we begin running because the fire alarm's going off, correct?
Well, something got my attention, plus I saw the demon flashing up on the phone.
Okay, and then what happens next? Let's go, keep going. You guys are both jogging, correct?
Yes, sir.
Scott Peterson is jogging now towards where he needs to go, correct?
Yes, sir.
And at that point, let me just pause for a moment. When you see him jogging, you see him acting up to this point, do you believe he's doing everything he can to be present and to help whoever needs him?
He was trying to get down to the area.
Okay. At no point does he say, hey, I'm out of here, I'm gonna go jump in my car. He doesn't say anything like that. Everything else was.
So later times, the state objects to this for speculation and the judge sustains it. But the defense does get it in here that, yeah, he basically believed Peterson was doing everything he could try to do at this point, which is the same thing that this witness was doing. They were running the same places, doing all the same stuff at this point.
Was focused on trying to be of service, correct? All right, next thing. So now you're driving towards the 1200 building, correct?
Yes, sir.
And pause for a moment. You had described Scott's demeanor. You had never seen him act this way before.
No, sir.
Had there ever been a scenario on campus in all those years that you would analogize or say was similar to what you were going through? No. It was like.
So now they start to get into all the stuff that was going on. This is unlike anything they've ever had to deal with before. It's like the worst school shooting ever. So it's understandable that everybody's freaking out. But again, it's not like he got in his car and drove off, the defense attorney said. But from somebody that was there looking at Scot Peterson, could you tell what he knew? Could you tell the decisions that he was making? Was he being a coward? Was he doing nothing when he should have done something?
Nothing else, correct? And even you, how are you feeling?
How are you feeling at that moment? Not good.
I can understand. Did Scott look the same way?
Yeah, he had a little bit more pressure. I think it was a bit more stress over him trying to handle the radio and stuff like that.
You saw that
He had even, so I was not doing good and I was there in the moment. And then Peterson had even more pressure and more stress and he was trying to deal with his radio, which he testified to before wasn't working. And Medina did not tell us what he should have. I mean, this witness is not good for the state.
he looked pressured, he looked stressed, he didn't look like a man who was calm and just standing around doing nothing, correct?
He's on the radio. Majority of the time.
And keep going. This is between the 700 and 800 building, correct?
So again, and he says this was not a man that was just calm, sitting there doing nothing, not wanting to help people, being a coward. And the answer was no. We're going to jump ahead a little bit more where he gives another explanation of exactly what it looked like Scot Peterson knew or was doing in the situation.
Correct?
Yes, sir.
You didn't know they'd be shot by any bullets, correct?
Correct.
You recall seeing my client as he's doing all this. He's sweating, correct?
Yes, sir.
He's breathing hard, correct?
Yes, sir.
And it was your words that I heard on direct, correct me if I'm wrong. I didn't think he knew what was going on, correct?
Right. Yes, sir.
Tell the jurors what you.
He said those words on direct. He is the state's witness. And he said, I don't think Peterson knew what was going on, which is exactly what the defense has been trying to prove. I know they do not have to prove anything. They have no burden, but what they have been trying to prove the entire case is Peterson did not know what was going on. And because he did not know what was going on, he shouldn't just go running into buildings for multiple reasons. Number one, friendly fire. Number two, he could be running away from where the shooter is. Number three, he could be running towards a dangerous situation that he's not going to do anything to help. Number four, he could be running out into sniper fire. So he needed to assess and get the information because he did not know what was going on. And this is coming from an eyewitness that was there, standing there with Peterson, receiving the information with Peterson. I think this is kind of a different perspective than a lot of these other officers that just come in and say, I would have gone in and saved the life and been a hero, which can absolutely be true. But that doesn't necessarily mean they were standing in Peterson's shoes and knew what Peterson knew and saw what Peterson saw. This guy is the closest one.
You meant by that?
Well, when I looked at him, he just had like pretty much like a blank look on his face. There was so much going on, and I can imagine the stress, the pressure that he was under. So, and I pretty much just like I felt helpless. Like there's nothing I can do.
He felt helpless. There's nothing he can do. Peterson probably felt the same way.
And I just don't think he realized pretty much what was going on.
And he did not realize what was going on. I mean, I would play this guy's testimony in closing argument.
But you do see him monitoring both radios in real time to try to figure it out, correct?
Yes, sir.
And while he's monitoring both radios, trying to figure it out, he had his pistol out. You saw that, correct?
Yes, sir.
So he's doing something.
You also remember him scanning the area with his handgun drawn, correct?
Yes, sir.
And to you, it appeared that he was trying to look and see where the shooter or shooters may be located. Isn't that correct?
Yes, sir. He did look out straight ahead and did look to the left and to the right. Yes, sir.
Okay.
I mean, to me, again, this is another witness that would really make it difficult for me to convict Scot Peterson at this point. Let me know what you think in the chat at this point, because the state's almost done. We're getting through the end of the state's evidence, and this is one of the witnesses they put on to prove he did something wrong. And he proved he didn't know what was going on. They didn't get information they should have had. He was trying to do something. He was stressed. His radio wasn't working. So we're really going to put this guy in prison when all of those factors outside of his control were happening? I mean, maybe he froze. Maybe he didn't do exactly what we all would have wanted him to do to be a hero. But did he commit a crime? And again, this says nothing to what the victims have gone through. It's deplorable. It's horrible. Nobody wishes it upon them. Nobody's trying to minimize that on this channel. I promise you that. He also agreed, this witness, that he heard a few gunshots, which again goes to the perjury charge. The lawyer wanted to keep asking him about, what Peterson was thinking. State didn't want him to be able to say that, which I think is interesting. It's their witness, but they don't want him to be able to say not what Peterson was thinking, but was he doing everything he could based on his perception. So it seems like it almost sounded to me when you listen to it like the state was trying to not let the jury hear that. If I'm on the jury, as I've heard from jurors, when they hear a lot of objections with a state witness, they're like, why don't you want your witness to tell us this? They also didn't want like a picture of a tree coming in, which again, it was like a series of events that seemed like the state was, if I'm a juror and I don't understand the process, maybe the state's trying to hide something from me or something, which I think is unnecessary in this case. On redirect, the state just like confirms this guy doesn't have police training, which, not great if it's your witness. Another officer testifies after this. When you hear shots, you go in, you try to save lives. Yeah, all this other stuff, whatever, if you don't know, whatever. But if you hear shots, you go in, you try to save lives. But he also agreed he did not know what Peterson knew at that point. But that he would also be careful to avoid friendly fire. That's why everybody doesn't rush in from every door. There has to be a plan. You show up, you assess. That's what he did as well. So it was a very interesting kind of day of witnesses. And then we get into today's witnesses, where the state presents their last bit of evidence and testimony. So the last witness the state called is the officer that did the actual interview with Scot Peterson, the lead investigator on the Cruz case. And he was basically called by the state to prove the perjury count. And he testified for the state that he did do the interviews and he did swear Mr. Peterson under oath before he told him the 2 shots or 3 shots or whatever it was. And that was obviously a false statement, which you need more than that for perjury. And on cross, he says that Mr. Eiglarsh, I think is how you say his name, deposed him for 2.5 days. And very artfully, the defense attorney shows a picture of Nicholas Cruz and says, actually, why don't we just, how far back? So let me see if I can put it up there. It's too far back. So he shows a picture of Nicholas Cruz on the courtroom TVs, and he says, that is the person responsible for this, isn't it? And the detective agrees. Nicholas Cruz is responsible for the school shooting. But that doesn't totally absolve the defendant in this case, and that is why we are here. So they continue. And I thought one of the most interesting parts for the defense here, especially as it relates to the perjury charges, was the worthless radio communication system that they have and how it wasn't patched. They weren't sharing information. And the reason that's important is because during the interview, all of the information hadn't been given to Scot Peterson. So his knowledge was still limited. And based on that limited knowledge is the statements he was making. And so if the radios were all screwed up, that kind of confirms that he had limited knowledge, at least somewhat. So let's listen to this and then kind of get to the crux of what this perjury charge is really asking.
Somehow that information was being disseminated to BSO?
Again, when I'm on scene, I didn't know that even existed. Obviously, afterwards, I learned about that issue.
Also, in terms of patching, did you think that Coral Springs Radio would have been patched with BSO so that they could be working in concert together?
That's a normal protocol when you have agencies that are not a part of the BSO
Right.
Radio system.
It's normal protocol, but it was protocol that you learned was not followed in this case, correct?
I think it was attempted, but because the radio problems that day on both ends, they weren't able to accomplish it. I think they tried to patch, but the BSO radio system,
So there are radio problems on both sides. They tried to use it and patch it appropriately, but they couldn't because the problems were so bad that day. That alone feels like enough to be like, the guy didn't have all the information.
was failing based on
The radio systems were failing. I'm going to back it up so it's not really cut up and you can actually hear him finish his answer.
the radio system was failing based on how many radios were trying to key up at the same time, where you would, I don't even know what the term is anymore. It would go into fail soft mode where you couldn't transmit and couldn't hear.
How fair is that to officers who are on the scene?
I was one of the officers on the scene. I mean, I don't know how fair it is. That's just what happened. It's just the way, unfortunately, the way it happened that day.
When you say unfortunate, why is it unfortunate?
Because again, you're trying to gather real time
The defense attorney obviously wants him to say it's unfortunate because maybe we could have done something if the radios were working. But because they weren't, that was another problem in this puzzle.
intelligence, and as police officers in the modern era, we rely on our radios.
Right.
And to get communications from people who have the best real-time intelligence. And in this case, because the radios failed, that was a difficult task.
Impossible for some who would try to get on their radios and would throttle, correct?
Yes.
Explain for the jurors what would happen if someone had some important real-time intelligence to convey to my client or other officers on the scene. Tell us what would happen.
Again, the technology is well beyond my expertise, but if you try to transmit, it would make this alarming boinking sound, which meant it wasn't coming over because there were just too many people trying to either transmit or they were flooding. There's only so many slots that you can get on the radio system, and once that overfills, it goes into fail-safe or fail-soft mode.
And so first responders, you would agree, were grossly hindered by the fact that the radios were not working properly, correct?
I would say that's accurate.
I mean, they were grossly hindered by the fact that the radios were not working properly. That's a fact. I understand this was a tragedy, deplorable. We should do everything we can to prevent anything like this from happening again. But this feels very unfair for the defendant in this case. And I know people are going to say I'm biased, and I understand that, and I get it. And if you feel differently, that's fine. Let me know in the comments. But this is a really tough watch for me, this whole trial.
The fact that the radios with Coral Springs were not patched, correct?
But yes,
And that nobody from Coral Springs called BSO dispatch to say, hey, here's some information you might want to convey to your officers, correct?
I know they tried to transfer some 911 calls, and in some cases that failed as well.
Even the 911 calls didn't go through.
Because Coral Springs was getting the 911 calls from, in some cases, inside the building. And when they would try to transfer them to BSO, the transfers weren't called.
And so all that information was never conveyed to BSO officers like my client, isn't that correct?
No, it wasn't transferred. It wasn't given over the radio at all that I can recall.
And there's no question through your investigation, you learned that there were numerous children calling in from the 1200 building, indicating exactly where the shooter was located, correct?
Children and teachers.
So people are calling in to this system saying the 1200 building is where the shooter was. If Peterson would have known that, then he would have had a duty to charge into the 1200 building, but none of that information was ever relayed to Peterson.
And that went to Coral Springs, not BSO, isn't that correct?
That is absolutely correct.
You agree that that is unacceptable, correct?
Yeah, that's his thing. His opinion, he's a fact witness, not an expert. His opinion is not relevant. Go ahead, sir.
That is not how you guys were trained, correct?
I would say it's not optimum because it's not the way we're trained. It's just the fact that if you're responding to an incident, again, you're trying to get real-time intelligence by whatever means you can. And a 911 call from inside the building is real-time intelligence.
When you arrived on scene, I think you testified earlier that a lieutenant colonel told you that someone was shot, correct?
So that was while I was at the public safety building.
Okay. That information never came out over your VSO radio, correct?
I think that may have been one of the guys on Holmberg actually saying he had a guy shot at the football field, which was Mr. Lamont.
That is correct. Football field. Did you hear that announcement saying that somebody was on the football field being shot?
Well, when a lieutenant colonel came running in, he didn't say football field. He just said there was a student shot and there was a shooting at the school.
My question is, did you hear Deputy Kratz announce in real time that the shots were coming from the football field?
I didn't the day of the incident. I heard it afterwards while I was doing my best.
So again, just more information that was incorrect that Peterson had to deal with that day. So some other stuff came up. The judge did not allow this witness to be impeached on some things he said in his deposition because he didn't feel like they were relevant to what he was testifying about today. Some of it, I don't really agree with. If you guys have specific questions about that, let me know in the comments. But also at the end of the trial, right when the state rests, the defense also wanted to ask this witness specifically about, and this was part of what he wanted to ask him that was in his deposition. The judge didn't allow it, and we'll get to why. But outside the presence of the jury, the defense questioned this witness and said, "You only interviewed my client because your superior told you to." Answer was a roundabout way, basically, yes. And your superior only told you to because parents were complaining. And the answer was yes, but while that was the only reason my superior may have wanted me to interview Mr. Peterson, I also wanted to interview him as part of my case. I had other reasons. That was the witness's answer. Judge did not allow this to go before the jury, so the defense proffered it for appeal because he thinks that's important, obviously. Again, if we revert back to his opening statement, he wants to push this narrative that this was political. Not political, but that they needed a scapegoat, and Scot Peterson was the scapegoat. So this was coming from the sheriff. This was coming from the supervisors down to make sure they had charges, to blame Scot Peterson, to make the victim's parents, make them feel like they were getting more justice, regardless of if this crime was appropriate to charge and whether this would serve a just ending. And it seems like the defense attorney has the ammo to do that and is not being allowed to do so. And I think there are arguments on both sides as to whether or not that's appropriate. But with this perjury charge specifically, I think the state has basically painted a picture that you have to believe that Scot Peterson knew that what he did was wrong and negligent and cowardly, and he lied in this interview in order to cover that up, to say that he only heard 2 or 3 shots to make it seem like he didn't have any information. And in only 2 or 3 shots, it would be impossible to figure out where the shooter was coming from. And in only 2 or 3 shots, it would have been impossible to do anything. Because shots fired the first shot, then only 1, maybe 2 more. What are you really supposed to do in that time period? So basically, he had to lie to try to cover it up. And I think you have to believe that in order to convict on these perjury charges. I've got a tough time with how close they were and how inexact the interview was, and how it was not like a deposition in court where everything you knew was going to be, basically used against you, but instead he was trying to help him in an investigation. And, again, perjury is tough to prove, but we'll see if the state ends up getting there. And I can't wait to hear them kind of wrap it all together in their closing arguments. But first, we get to hear and see the defendant's case in chief. I do expect the defendant to testify. Let me know in the comments if you agree. Do you think Scot Peterson will testify in this trial? My guess is yes, but I can't wait to hear yours. Let me know. The state has now rested their case. Where do you stand? Do you think they've proven this case beyond a reasonable doubt? Or do you feel like Scot Peterson is still not guilty since he's presumed innocent at the beginning of this trial and the state has to prove the case beyond and to the exclusion of every reasonable doubt? So I want to know where you are right now. We're not done with the trial, but just to kind of keep us going as potential jurors, if we were to take a vote right now, just interested to see where you all are. Again, thanks for hanging out. Thanks for listening. Hit that like button if you are still interested in this trial, and we will continue to bring you content on it. So before we finish with the state's case in chief, and before we get to the defense's case in chief, I do want to watch together the JOA argument. We're going to skip the defense's argument. We've kind of already heard what it is, specifically about caretakers and things like that, because the exchange between the state and the judge is really, really interesting to me, because a lot of people have thought the judge was really hard on the defense attorney throughout this case. But let's listen to kind of what he thinks and some of the arguments he's making with the state as they respond to the defendant's JOA argument.
Your Honor, standard putting in evidence in light most favorable to the state has put forward considerable evidence.
So he just basically argues the standard and if light most favorable to the state, judge, in this very standard motion that you always deny, we have put forth considerable evidence of these charges. Therefore, you should deny the defendant's motion, expecting the judge to just summarily deny it. But the judge is saying not so fast. And again, I'm sorry for the audio.
To the jury, to allow them to go back and apply that to the law the court gives them, and they all account for the information.
So, Mr. Mayor, let me ask you this. When does the defendant become a caregiver?
So his question there, in case you couldn't hear it, is, let me ask you this, Mr. Prosecutor. When does the defendant become a caretaker? And it's an interesting exchange here.
When does the defendant become a caregiver for the listed victims accounts 1 through 10, or 1 through 7?
Well, when does he become a caregiver? He becomes a caregiver once he becomes the SRO of the school. SRO of the school. If you want individual to those.
Well, he's not charged with anything as it relates to.
He basically says he's always a caretaker. And the judge is going to say, well, what about all the kids on the first floor? Was he not a caretaker for them? Why isn't he charged with all of those crimes?
Victims of the first floor, correct? That's right. So I presume that means at some point you determine, the state has determined he's not a caregiver that has criminal liability for what takes place on the first floor. Well, you tell me he does have criminal liability for what takes place on the third floor. So my question is, when does he become a caregiver for people on the third floor?
It's a great question. Is he not a caregiver for everyone in the school at all times? Isn't that what you guys are arguing for a resource officer, school resource officer, not human resource officer? And the state says, well, he couldn't have gotten to the first floor in any way to help them, so we didn't feel like it was fair to charge him. But the judge's point is well taken. If he was the caretaker and he failed to take care of them, and this was under the normal, how the caretaker statute is supposed to be used, you would be able to charge for everything that happened on the first floor. But it's not.
On his way to the scene, not to charge him. First of all, we could only charge him with what happened after he arrived, which is about the time that he's with the shooter device, killing device. So
So you're saying it's a caregiver for everyone, but I'm looking at the first element as to neglect of a child, page 27.03. You're saying the first element doesn't apply to anyone on the first floor because it's nothing that he did or failed to do that would have changed anything that happened on the first floor.
exactly. We didn't feel that because he wasn't even there yet, could have gotten there any faster. When he was there to charge him. That was a decision made, a violent decision was made.
So he's a caregiver for everybody,
Yes.
all the 4,000 students in the school.
So he's a caregiver for everyone, all 4,000 students. Mind-boggling, pretty unfair if you ask me, because again, that is not what the caregiver statute is meant for in Florida. But that's what the state's trying to argue here, fitting a square peg into a round hole.
And the 40 acres of the school grounds. Or whatever the size is. In other words, every school resource officer, the state's position is every school resource officer is a caregiver for every student at every public school upon setting foot on the campus.
The school is
I'll just tell you, I feel like this judge has been harder on the defense than the prosecution throughout the case, sustaining things. I think he's been good. I mean, I think he's been smart, tough, decisive, which again, that's my favorite quality of a judge is to be decisive. But he's like, that's what you're telling me, huh? You can hear the sarcasm in his voice.
contract. Right. He is the SRO. That's the special relationship that you see from the contract. You see the various training that he has a special relationship with the
Look at the judge's face.
student, faculty, and administrators of the school. Because he takes on that role, and it's a contractual role that's set. And we put all those documents into evidence. You see he has special powers. SROs, right? They can detain students. They can search without probable cause. They're given all these various extra rights that a patrolman on the street does not have, and even if that patrolman came into the school, but the SRO does. The SRO is given a different position, and he operates under a different set, in some instances, under a different set of rules. So you have a very special relationship between him and the school. What is he there for? He is there to protect the students. That's the whole point of it. And that's why he's the head of security. You should know the school inside and out, know the security system inside and out. He is there for the daily stuff that goes wrong, and then when, God forbid, things really go wrong. It doesn't matter. That's his position.
So let me ask you this then, next.
Can I just add one more thing? Sure. We feel that at this point, that would be a decision for the jury, the caregiver decision. That's not, you made a legal decision way back a couple weeks ago about, or maybe it's even longer than that, about what statutes you're going to apply caregiver. But for now, it's the state's position. We've given.
It's not my decision. I'm just looking at the standard instructions from the Florida Supreme Court. You charged them under 827.03, subsection 2B, and the Florida Supreme Court has promulgated standard jury instructions for 827.03, subsection 2B. 827.03, number 2, little b. And the third element is that the defendant was a caregiver for whichever alleged victim.
Right.
And right, that's a jury question, but I guess I'm trying to figure out, looking at it like most favorable to the state, have you proven that?
He's like, yeah, it's a jury question, but have you even provided evidence that a jury could make that determination? Because if the judge finds that no reasonable jury could find that this defendant was a caregiver, then the judge should acquit. It's not going to happen. It almost never happens, but usually judges do not push back and fight this much with prosecutors on a JOA argument. So this is telling of where the judge feels that maybe the judge is kind of where I'm at, where it's like, I wish Peterson would have done more. I wish he would have been able to do more. I wish he knew more. I wish the radios weren't screwed up. But like, he's a criminal under the caregiver statute, a felony.
Well, also there was evidence of him being a mentor. One of the reasons behind the program, and I believe the case was cited to the motion to dismiss Brady. That's another role that he had, is being mentors to the students at the school. That's part of the program. So there was quite, well, state's point of view, there was quite a bit of evidence that went in for the jurors to decide whether or not he has a caregiver position.
The second element, let's say you get over the caregiver hurdle, the second element, as to counts 1 through 7, says in doing so, or at least in counts 1 through 6, the defendant caused great bodily harm, permanent disability, or permanent disfigurement to the listed victim. Did Mr. Cruz do that?
So how did the defendant, again, here's the second question, which a lot of you have been asking, and I think the defense attorney's done a great job of getting people to say, Cruz did this. Put a picture of him up there. Talk about him in opening statement. Make sure he's a highlight in this trial because he is the bad guy, not Scott Peterson. He is the bad guy. And now the judge is even saying, didn't Cruz cause their bodily harm?
You taking that to the jury instruction?
Yes, sir. Element number 2 of neglect of a child, 16.5, is the defendant caused great bodily harm, permanent disability, or permanent disfigurement to, and then you fill in the listed victim. So tell me what the evidence is that he caused great bodily harm, permanent disability, or permanent disfigurement?
Well, that, Judge, I believe, I've got it correct. That comes from it's in the jury instructions underneath the list of the 4 elements that you proven.
They're going to say he failed to stop it. That's how he caused it. Now, is that fair? I don't know. You tell me.
It's also in the statute that comes from the neglect itself can be based on repeated conduct or a single incident or omission that resulted in or reasonably could have been expected to result in serious physical, mental injury or a substantial.
So he should know that if he doesn't do his job and he is negligent as a caregiver, that people can and will get hurt. And that's exactly what happened. And that's how he allowed it.
Of death to the child. It's all read together because that's the whole purpose of it, is that you did not give the care you were supposed to do, and that resulted in the injury. So you, by your admission, by not doing what you were supposed to do.
So he caused it by failing to act. That's the state.
That's what they're arguing. You got to say yes if you're the state for that.
I know, I realize the word cause, at times makes people maybe pause for a second. But that is how the statute reads, and that is how it's read in pari-mutuel, other paragraphs in the statute itself, and it's in the jury instruction. That omission, at least in this case, we're talking about, it's not always an omission either. We're not saying there's some things that were omitted, but there's also some things that he did that didn't do any good or weren't helpful. So he did do certain things and did do other things.
Yeah, I understand that, but in 827.03, it says, the person who willfully or by culpable negligence neglects a child and in doing so causes great bodily harm, permanent disability, or permanent disfigurement. It's in the jury instruction as well. And he caused it. So the state's position is that the defendant caused these injuries, or at least enough so to be held criminally responsible for them?
The defense, it comes, yes, because it comes from the qualification. That's in that's there in the instructions and in 82703 itself. The neglect was underneath number 3. Neglect of a child may be based on repeated conduct or a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. So the conduct, right, and enables the killing to go on inside the building.
You would have to know that, right? The jury would have to be convinced through your evidence, again, I'm supposed to look at the light most favorable to the state. The jury would have to be convinced that he knew there was someone in that building shooting people.
The judge is literally reciting the defense's arguments. In order for him to have caused harm in that building, he would have had to know what was going on in that building, that was the building the shooter was at, and have been able to do something about it in order for him doing nothing to have caused the damage. I'm surprised at this. I mean, the judge is listening, and this is why, you know, I've had cases where the judge has hammered me, it's felt like, throughout the case, and then at the end, they'd be like, wow, you did a really great job, and the jury came to the right verdict. And I was like, whoa, okay. And I've had other cases where the judge has given me everything, and it didn't go as well as I wanted it to go. You know, so you don't always know what the judge thinks, just how they're making calls. But this is an unbiased judge. He's just sitting watching the trial, and he's making the calls that he thinks are right, regardless of how he feels about the case. Because it seems like he is thinking, I don't think you should have brought this case. This is my guessing here. But even though he's thinking that, he's still giving the state the rulings that he believes they're entitled to based on the rules of evidence. This is exactly how a judge is supposed to act.
People, and that he failed to act or acted incorrectly, so his act or omission caused these injuries. You would have to know that that was happening.
You have to know that the injuries were happening or just the shootings.
You would have to know that danger existed. You would have to know that something's going on in that building.
Well, here, again, I think at this point you're touching on another issue that would be a factual issue for the jury to make a determination on, whether it does fit into the statute. I mean, we've laid out all the things that were done or not done during that time period.
Well, listen,
There's not, and you see the five.
I don't get a vote, but let's say if I believe in the light most favorable to the state, that you have proven that the defendant maybe didn't follow his training or act in the manner that was consistent with the training. But that's not what the jury's being asked to decide. They're being asked to decide if he committed the crime of neglect of the child. And the crime of neglect of the child says that he caused the injury. So I guess that's the part that I'm stuck on.
And that's a big difference between just the criminal negligence statute, which we talked about when we talked about the charging document.
He caused these injuries.
He caused the injury because his omission, his failure to do what he was supposed to do. He didn't do anything. He goes over and stays for 48 minutes in one spot. Instead of, as you heard some of the testimony today, open the door, check to see what's going on. Why talk to the students? Go for the sound of the shots. It was all like they're laid out in the information, actually, at various points. Not speaking to the students, not going to the sound of the gunfire, not speaking to the students. There was a whole plethora of stuff that he could have done that he didn't do, and that then forms the basis of the causation. Causes the killing to continue on because he isn't doing what he's supposed to be doing in interfering with his child.
Okay, well, at this point, again, understanding we're not at the end of the trial, we're not at the end of the evidence, but at this point, I am to look at the evidence in a light most favorable to the state. I don't know what part of the evidence, witnesses, or testimony the jury's going to believe or not believe, but if they believe everything from the state's point of view, I guess they certainly could believe that the elements of each crime have been proven beyond a reasonable doubt, or in fact, they may conclude that it hasn't been, but that would be their decision, at least at this point. So respectfully, the defense motion for judgment of acquittal is going to be denied as to all counts. Next. Defense, do we have witnesses ready to go? We did. Okay. Anything we need to address before we bring the jury back in?
No, Your Honor, just note our objection to the court not granting this motion of judgment of acquittal. The court was struggling with it, even in a light most favorable to the state. They did not meet the elements of the crime, and I don't believe that we should be continuing with these charges at this time. Okay.
So again, one last shot there from the defense. And to me, the judge's struggle, I loved that. I love that we were able to see the judge struggle through that. He probably made the right call legally to let this continue forward. But that feels like a lot of what the chat is struggling with and what I've been struggling with watching this, listening to the testimonies. Like, I just don't see how we get to this criminal caretaker or even criminal liability at all throughout here. So I added this part on at the end if you can't tell. So we're going to clip this on to the end of the video. Let me know what you guys think. I'm really interested in your thoughts on how this case is going. And later on in the week, we will talk about the defense's case in chief. But until then, that's all I've got. I will see you guys on the flip side. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.